Indigent means a judge has determined you can't afford to hire a lawyer. In this case, the court will appoint a lawyer for you to prepare your defense and for your trial. But you may require an attorney for more than just your trial. If you are found guilty, you will more than likely want to file an appeal and a writ of habeas corpus. The Code of Criminal Procedure identifies the circumstances when you may have a court-appointed attorney and how long that attorney has to prepare. We've already seen the Code of Criminal Procedure says a defendant is entitled to an attorney when the punishment includes confinement, in other words, jail or prison, or a judge decides it's in the interests of justice. That's at the trial court level. Types of courts which hold trials in Texas are district, county, justice, and municipal courts. In most cases, defendants have the right to appeal a guilty verdict from these trial courts. An indigent defendant also has the right to appointed counsel after they've been found guilty, at an appeal to a court of appeals, which could include the Texas Court of Appeals, or a county court on appeal from a justice or municipal court, or at an appeal to the Court of Criminal Appeals made directly from the trial court. This means death penalty cases. An indigent defendant also has the right to an attorney after they have been found guilty at trial and a petition for discretionary review has been granted. For example, a defendant is tried in district court and found guilty. He appeals the case to the Court of Appeals, who is required to hear his case. The Court of Appeals affirms a decision and says his guilty verdict is valid. He next appeals to the Texas Court of Criminal Appeals. The Court of Criminal Appeals is a discretionary court. They don't have to hear his case if they don't want to. But if they do, the defendant is entitled to counsel at this level as well. An indigent defendant is entitled to appointed counsel at a habeas corpus proceeding if the court determines it's in the interests of justice. An indigent defendant is also entitled to an attorney at any other appellate proceeding if the court determines it's in the interests of justice. Finally, an indigent defendant who is entitled to an attorney is allowed 10 days to prepare for trial. A non-indigent defendant is allowed 10 days to obtain a lawyer upon notice of the court. So if you're indigent, your lawyer has a minimum of 10 days to prepare for trial, and if you're not indigent, you have a minimum of 10 days to hire an attorney. Now remember, 10 days is the minimum. In actuality, a defendant will probably have much more than 10 days to prepare or find an attorney.